Thanks very much. My day job is a technology lawyer, and what I'm generally doing is helping people buy or sell technology-related legal services. I'm giving the legal services in relation to their purchase or sale of technology or related products or services, and also advising in relation to their use within their different types of businesses. And I'm about 15, 16 years into doing that. And so I'm coming along today to talk a little bit around the law in relation to artificial intelligence. I'm going to do that for a little period of time. I'm not going to spend years and years in relation to that because the really short synopsis is there isn't any specific law in relation to AI. So what we're trying to do is apply existing legal principles in relation to the use of this new technology. And it produces some problems and some challenges, but I think we also produces some really easy legal answers to the problems that are out there today. The question really is whether they're the right answers, actually, rather than whether we know what the answers are. And then what I'm going to try and do is look a little bit about the projects and implementation of AI projects, in particular the challenges for the lawyers. And I appreciate this room is probably not full of lawyers, but you will be hamstrung by lawyers at some point in relation to asking for advisors, be it the contracts, be it the sign-off, be it in relation to the risk note that you want written. So perhaps it's good to understand a little bit about those projects and the challenges for those projects, for AI implementation projects, and why they differ from technology projects just more generally, which we're pretty used to doing and implementing now. We have in tech terms a long history of doing those kind of things, 20, 30, 40 years worth of history. In law terms, that's no period of time, but in tech terms, that's a long time. And then I think I just wanted to talk a little bit about some of the things I think are getting ourselves ready or legally ready for artificial intelligence within the businesses, be that from the customer side, people buying in those services or provision of services that use or utilize or fully and fundamentally just are artificial intelligence, because we're already learning about some of the pitfalls and some of the risks in relation to using of those technologies, and where the law can really hinder what's trying to be achieved. And the frustrating thing from a legal point of view, especially with a newer area of law like technology, is you see all these great, and a lover of technologies on an individual scale. You want to see the law help and develop rather than hinder, and of course it gets a bad press. We'll be talking, I have to mention data privacy because you've got to mention that if you're a lawyer and working in the technology space just at the moment. But it gets a bad press because of the impact it's having on different types of projects. But there are things that can be done to minimize that press. And so the other thing to bear in mind is really about the impact that even my profession's seeing. So when I first did this talk about 4 years ago, this slide was full of just news articles from, the FT and the BBC and even, other things were saying AI's coming, got to be aware it's going to impact society in general. Well, listen, these are news stories just about my profession. Now, mine is the most Luddite profession in the world, right? Law services, legal firms have generally not changed in structure or use of tools beyond moving from the pen and the ink, moving to Word and email. That's our big technology development. But even we are feeling the pressure, and even our industry is feeling the change in relation to the implementation of AI services. Even I now use that in my job. And I say that simply because I think it's a useful reminder to everyone that actually the impact it's going to have affects so many more areas of our business society and obviously our consumer and wider world that we live in. Because that's an important point from the legal impact as well. Because what does the AI mean for the law? Well, the interesting thing about the law to date in relation to technology is I think the law, and when I talk about the law, I'm predominantly going to be talking about it in an English and a UK perspective. Although a lot of the legal concepts start to become harmonized, in particular when we're talking about data privacy and data security across a broad European network and actually even broader. And then when we talk about things like intellectual property, those kinds of laws and legislations, again, there are large international treaties where a number of countries have very similar, if not exactly the same kind of legislation. So we can talk in relatively general terms. So the law's done really well, I think, today in dealing with technology advancements. It's dealt with some things that have come along which have absolutely revolutionized society, and it's not really fallen over. And I think about things like the internet, you think about mobile devices and apps, you think about cloud computing. All these things have come along, and we need to tinker around the edges. We've had to look again at conclusion of contracts online. We've had to think a bit about data privacy. It wasn't a big worry before. We've had to think a little bit about intellectual property ownership and digital rights management. But, in terms of fundamental legal points, I don't think they're huge bits that the law's been challenged by technology and not been able to deal with pretty well. I'm maybe a bit biased because I'm a lawyer, I think we're all great in what we do, but I think the law's done pretty well in relation to that legislation. In particular, actually, in this country where we've had a decent common law system rather than a written down civil code, which means the court's been able to, and the lawyers in the courts have been able to use the common law system to sort of bend and wave a little bit to make sure things fit in and evolve rather than develop. But the interesting thing about artificial intelligence, I think, from my point of view, is I think it starts to challenge some of the concepts within law that haven't really been properly challenged previously. And these concepts it's starting to challenge aren't things around how do I serve notice in this area, or some minor issues around responsibilities or liabilities. These are fundamental concepts in relation to contract law, in relation to tort and responsibility and liability and criminal law. And one of the first things I think it starts to challenge, because this concept underpins near enough every other aspect of law within most societies, is the concept of personhood. Now, you might have heard about personhood, and we'll come on to a couple of areas where it's been talked about in recent EU studies in relation to, EU Commission papers and reports in relation to one of the core areas to sort out. We're used to personhood. It started with the concept that the king had certain rights. And then the king and the lords had certain rights. And then the king, the lords, and the wider gentry and the rest of society had rights. And that right is really important because it underlines and underpins who's able to own stuff, who's responsible for stuff, who's liable, who otherwise has a duty owed to it. All of these things stem from the fact that we can recognize that thing, we can recognize that thing having a legal personality. Now, historically, that was a small group of people. And actually, if we think about it, how that then has developed, the law has evolved to deal with differing and widening out the groups of people it is. And of course, the Romans had to deal with concepts, the Roman law, which underpins a lot of law, not in the UK, but underpins a lot of different legal systems, in particular throughout Europe. But the Roman legal concept, which came along and said, hang on a sec, I'm a Roman emperor, I'm a citizen of Rome, and I need to be able to go and trade in the market, but I'm not going to trade in my market on my own. I need my slave to be able to do that. My slave needs a legal personality to be able to conduct claims. So they come up with a concept called peculium. And that peculium concept is about being to some kind of limited right in relation to the individual. So the law's starting to show itself very happy to change and adapt when it needs to. And of course, we more readily understand it more recently in the last 100 or so years as seeing the law starting to give the concept of legal personality to different things, be that to trusts and families, and different concepts under family law and trust law. Be that to the government has a legal personality status, so they can have responsibility and enter into contracts. Be that under executors, under wills. Be that, most obviously, really, corporations and different types of businesses. Be it partnerships, I'm a partnership. They're part of a partnership as a lawyer. Be that, public limited companies, etc., etc. All of this is the law having to show itself developing as that concept of personality has expanded to deal with what society requires of it. Now, previous technologies have not challenged this concept at all. No one is wondering about whether, just generally the iPhone should have some kind of legal personality. But the newer technologies, and sorry, I should have started off this with a bit of a massive caveat. I'm interested in technology, I know a little bit about it, but I have a feeling I'm particularly outgunned in this room. So when I bandy around terms like AI and machine learning, imagine it's the level of knowledge of someone who's been on Wikipedia and done a fair bit of reading and in there, rather than a deep understanding. But what I do know is this: it's starting to be conceptually different to the ways that previous versions of software and other kinds of computer learning have worked, or computer machines have worked. So this concept hasn't previously been challenged. This concept of personhood hasn't previously been challenged by any kind of technology, and I think it's starting to be challenged now. And we just have to think about some of the other areas, or some of the areas of law where we see this challenge starting to peer in. And let's have a think a bit about what happens with this challenge at the moment. So, for example, what does this mean for intellectual property? If you're involved with a tech business, if you're involved with actually most kinds of businesses these days, a huge amount of the value of that business is around the intellectual property of that business. If you're creating something, it's the only thing really, the thing you're going out to getting investment and market to. So, how does IP law work? And how does IP law work with technology at the moment? And of course, I'm predominantly talking, when I talk about intellectual property, in relation to the concept of copyright, but obviously there's a whole host of different intellectual property rights, and I'm sure we're kind of vaguely aware of them, if not more so in relation to database rights, in relation to trademarks and patents, etc. But let's predominantly talk a bit about copyright, because copyright's been one of the underlying pieces of legislation, or rights, which have existed and helped the development of technology. So what does IP law recognise? What does it already do in relation to technology? So let's have a think. When something is created by a technology or on a computer or developed in that way, the IP can exist in that. Just because it's not written down, not drawn, not sung, not written down in musical form, intellectual property can exist in that, not a problem at all. The legislation, the Copyright Design and Patents Act 1988 deals with that very simply. When that creation's been done by a machine, when it's been conducted by the software itself, the law's already ahead of us. It's got no problem in saying, not a problem. Actually, we won't obviously think the software is owner it. Actually, the owner of that machine is the person who's made the necessary arrangements for the software to work, i.e. the person who's kind of set the software up to do so. And then it says, but hang on a sec. So it's already dealing with the impact of technology within usage and creation of things. And of course, it's also saying the owner of that right, the owner of that copyright, actually, if it's an employee-employer relationship, well, actually, the employer will typically own it. By the way, that can also be owned by corporates, by trust. It doesn't have to be a human individual being the owner of intellectual property at all. So the law sits there, I think, very easily and deals with intellectual property ownership and the imposition and the impact of technology within copyright, within the use of intellectual property more generally. Well, I have a feeling, quite often I ask this question, not a lot of people know, although there's a lot more in the news in the last couple of weeks. Obviously, I'd imagine people recognize this photo, right? The monkey selfie photo. And everyone's probably pretty familiar with the case that a monkey comes along and takes a photo, picks up a photographer's equipment and takes it. The photograph goes viral, obviously very popular on Wikipedia. Photographer suddenly realizes, hang on a sec, I want to make sure I'm monetizing that photo properly because it's my intellectual property, it's my copyright, it's my camera, my film. Monkey picked it all up. Wikipedia say, well, hang on a sec, actually, a few people challenged saying, I don't think that's your ownership because you didn't take the photograph. All right. We then have a long debate and discussion in the US, but then very interesting, PETA, the people for the ethical treatment of animals, get involved and say, hang on a sec, doesn't that mean that the monkey should own the copyright? Now, the reason I'm talking about this is, of course, here's a challenge for someone to say, here is something. It's one or two steps away in the evolutionary scale from us. Here is an animal which has shown something which deserves an ownership right in relation to that copyright. Now, to date, the courts have come along. It went to the 5th or 6th level in the US. The US courts have come along and said, that's lovely, but the law does not cater for animals to be the owner of that copyright. Thanks very much. It's really clear at the moment that isn't a concept, and animal owning isn't a concept that is currently envisaged by the statute, is not. The lawmakers haven't given that kind of permission. Now, I know there's a settlement a couple of weeks ago where they agreed that actually the photographer actually had agreed, I think, the photographer agreed in his settlement that a proportion of the royalties that he makes from any sales on will go back into animal treatment. But that wasn't a court-based that wasn't a court-based decision. So we haven't had any further discussion other than the courts rejecting Peter's claim that the animal had a legal status worthy of it owning intellectual property right. And I think that would be the case with someone coming along and saying, hang on a sec, here is my technology, as we've already had in numerous examples, here is my technology which has come along and written concertos, which has designed pieces of artwork, which has gone away and built its own piece of software. And of course, the technology can already do that, but we haven't had the debate, and anyone's brought any of those claims in relation to why that should be a different point than the law that I already explained, which is the law is out there at the moment, which says very, very clearly, that's lovely that the machine's gone and had all these creative steps in between you asking it to do so in this, but tough. The law is very, very clear. Now, I don't think it's up for lawyers to decide whether that's the right outcome to that question. I think that is more of a philosophical debate. But for one of these areas, this is one of those areas where I don't think the law is unclear. And it's actually it's quite helpful, I think, where the law and whether making sure that the law is clear in this area, because it means that when we're developing or using or buying or selling, we can be quite clear about understanding where the ownership's going to lie. We can do different things under the contract to change where that is, but as the law applies, we get a clear answer. And it's not always the case in law. So should the law change? Well, as I say, This is one of those areas that is being considered and discussed at the moment. You'll probably know that there was a House of Commons a Science and Technology Committee consultation in relation to the laws around artificial intelligence last year, concluded in October, in a sort of average kind of conclusion way, which was there's lots to think about. There's been very recently a consultation finished by the Lords Science and Technology Committee, and we're waiting for the output of that. And it's both of these have flagged that this is an area where people need to think more closely about whether this is still the right answer around the ownership in relation to IP giving us the right thing. You also, and I don't want to leap too far around, because I'll talk about it in a sec, but there's also been more EU reports in relation to thinking about legislation coming from a European perspective, and again, this is one of those areas that they've picked up. So, should the law change in relation to this? Who knows? I've got my thoughts, but at the moment, the law hasn't changed. It gives us a clear answer. But what we can see, obviously, is that we have got very recent examples of societies deciding that this concept of personality should be moved again and should be stretched to cover things that perhaps weren't corporations, weren't trusts, weren't your slaves down at the market, etc. So we've got two different rivers, actually. Bizarrely, they were both rivers earlier this year, actually. The Wanganui River in New Zealand and a tributary of the Ganges, both of which were granted legal status. Now, they were granted legal status to allow them to then bring actions to protect themselves for environmental reasons. But listen, the law is malleable. The law can change and flex to deal with these problems when we decide what we want the answer to be, if we don't like the current answer. But the current answer, I think, is relatively clear. Where else is it relatively clear, and is it still a right answer? Well, I talked a bit about the fact that artificial intelligence, I think, impacts on some of the fundamental areas in relation to in relation to the law, the sort of stuff that you do year one doing your law degree, contract, tort, criminal law. Okay, this is the founding basis of how the legal system is set up. And all of these are areas around where there is talking about the creation of legal relationships and duties, and then the breaking or expansion of those legal relationships and duties. And again, how do these concepts deal with existing technologies? Is there a question when I click the I accept button on Amazon, or proceed with order, or what have you? Is there a question that I am creating a contract or not between those suppliers? And the answer is no. There is really no debate that I'm entering into a contract there, that I'm doing the things necessary, right from case law back from the 1870s, of establishing an offer, and acceptance, and consideration, and intent to create legal relations. The fact that there's a computer-based and technology-based interaction and intervention to help that concluded does not destroy or remove that principle. Ditto in relation to tortious liability. The fact that I use a word processing tool to type out my documents, if I get my note wrong because spell checker accidentally amends and removes or changes the grammar so the comma's in the wrong place and my clause doesn't read properly, that is no intervention in relation to my liability, my tortious duty that I owe of professional credibility that I owe to my clients. I can't stand there and go, well, spell checker got it wrong. If I use a computer to defraud a bank, just because I've used the technology, that is no intervention in relation to my criminal liability to not perform the fraud, right? So the law deals with existing technology quite easily by just ignoring it in lots of different ways, going, that's great you've used this tool, this thing to do these things, but by the way, you still retain that responsibility. Entirely consistent with the fact that we have this legal personality and the responsibilities. And we'll come on to intervening acts in a minute, but generally we don't make excuses by the fact that these things haven't worked and done this in a different way. And the question just again becomes, should it operate in the same way for artificial intelligence? Should the fact that something has made a decision to enter into an arrangement, and I think this is very easy to think about quite quickly in financial services where we have an amount of algorithmic-driven trading already, should a decision to buy or to sell, which has been driven by some form of technology with less and less human input, should that trigger some kind of thinking that contract, that decision to buy, shouldn't exist because of certain parameters? Again, the law would say at the moment, it's really easy. Absolutely not at all. That isn't a discussion point. And the question for us, not this room, just generally, the question for all of us, and the question, again, that legislators are having to ask themselves, do any of these impacts of technology, should they ever reduce the liability for criminal responsibility, the obligation that I have professionally under duties of tort to my client or under contract and what I've entered into? But as I said, the answer at the moment is really simple. Very, very rarely does the intervention of technology remove any of these responsibilities. Very rarely does it break what we call a causal connection, that chain of between my action and responsibility and the outcome of that responsibility. Okay. The law sits there and says, you've done this is what the outcome is, be that a contractual responsibility, a liability, a duty owed to you, be that a tortious responsibility or a criminal act. Again, it gives us a very clear answer just at the moment. But people are looking, if I just jump a couple of slides ahead actually, these areas are where, these are some of the areas where people are looking very fundamentally about whether the law needs to change in this regard. And I talked a little bit about this, the Science and Technology Committee paper, and the AI paper. Actually, the most interesting was at the turn of the year was the Legal and Social Affairs Committee of the EU reporting to the Parliament to say, here's our detailed 50-odd page paper in relation to where we think laws need to go. Now, it's interesting with a few things. I had a couple of headline things, such as there should be kill switches for killer robots and the sort of stuff that the papers like. But actually what was more interesting were two things from my point of view, one of which was this recognition that some of these areas that are being impacted, you know, the fundamental concepts of contract or tort or IP or ownership or legal personality, they needed to be thought about properly, and we needed to make a decision not on a legally led basis, not on a finance-led basis, but as a society about where we think some of these tools and controls should go. And a second, slightly more disappointing one, I think, from a holistic point of view, was actually they were looking at the industry, the shape of industry, and in particular the shape of insurance to help define where we thought some of these liabilities might sit. And of course, this has been driven by really driven by autonomous vehicles, or at least the theory of autonomous vehicles. Because this was one of the obvious areas that I think people can latch onto to understand about how some form, and don't get me wrong, I completely understand that this probably isn't AI or machine learning in any technological way, shape or form, but it certainly, as people start to visualize in their mind, people making or computing making decisions that actually show and have very little human involvement. And I also know we're not there yet, but what this does is it's driven things to encourage people to have to think about this concept around a very simple thing, driving your vehicle. And of course, we've had an HSTA in the US saying, okay, let's consider the concept of the driver. Let's consider the concept of who has that responsibility. Is it actually the software business? Is it the car vehicle manufacturers? And of course, in this area, we've had the businesses themselves getting involved, and very quickly saying, hang on a sec, we'll take that responsibility. Volvo came out very quickly. You know what? Once we've got automated driverless vehicles, we'll take responsibility for the behavior. Let's not have that discussion about where the law should sit, because actually we can use it as a selling point. And of course, that's one of the areas where business is starting to define the agenda. Now, that's a very interesting piece around how legislation of technology in the last 5 to 10 years has developed. Business has been very clever, and I think the cloud computing market is the best example of this. Business has been very clever to self-regulate as much as possible to avoid legislators getting involved. And of course, in some ways, that's exactly the right thing, because legislating takes too long. When it gets written, it's out of date, and it doesn't make sense by the time it reaches the statute books. As soon as legislators try to get involved in any way, shape, or form in detail in relation to technology, it takes a year and a half to come through. It's already out of date, and it's circumvented because people like you guys and people like me are there saying, well, hang on a sec, this is the wording around it, and this is what we can do. What else should we think about, I think? Where else really is the law saying? Well, data privacy is one of those areas where people can indicate, sorry, let's take a step back. Everyone pretty comfortable with data privacy just generally, the protection of personal data, the stuff that identifies you and I as individuals. Now, typically, this is protected by a piece of legislation which is European-driven, but it's a UK piece of legislation called the Data Privacy Act. There's something called the GDPR, and again, that's probably been hanging over, batted around, which is a European-wide legislation. And regardless of Brexit, we're going to have our version of it, because we're going to need a version of it. It's going to need a version of it for us to be able to deal with the rest of Europe anyway. And the headline being that actually, if we get it wrong, there's fines of 2% or 4% of national turnover, of annual revenue for businesses. Sorry. So anyway, AI and DP do sort of struggle a little bit together, because of course, artificial intelligence is really us trying to combine some form of computing power with other concepts such as cloud, such as big data, such as analytical tools to make the best use of the ability to do things as quickly as possible in a way that, frankly, I think most ordinary people can't understand. Now, that's a really important problem for data privacy, because if ordinary people can't understand it, if I, as a consumer, as an individual, can't understand it, I can't consent to it. You can't get appropriate consent if I can't talk properly, if you can't tell me exactly what's going on in a way that I understand. It's automatically going to limit what you can do with data, because you're then going to have to start relying on other exemptions under the Act, which are a bit more narrow and restricted. So, the ICO, which is the Information Commissioner's Office in the UK, has been out and about telling people, listen, just generally don't be worried. And they've been very proactive in the last year or so, saying, actually, let's not hide behind regulation as this is stemming the flow of our business, etc. But the one thing that the ICO has been consistent on, not just with big data and artificial intelligence and more recently IoT, a couple of years ago IoT as well, and cloud as well, they've come along and said, listen, it's complex, there is a way through all of this, but you can't use the difficulty and the newness of the technology as an excuse for not complying with the fundamental principles of data privacy regulation, which is looking after you and me as the individual. And from an individual point of view, that's a good thing. But from a business point of view, or someone who's looking to explore or exploit in relation to new technologies, exploit opportunities, it makes it harder. So again, the law gives us an answer in relation to AI and how it works with DP. And actually, it really is going to be one of those things which define the shaping of certain tools where there's a data privacy element. And frankly, there's not much technology that doesn't touch in some way, shape, or form what would be considered personal data, because the breadth of the description now of what personal data is very, very broad. There's also some issues around what it means for workplace laws, and in particular two things, one of which is, I suppose, that vicarious liability of me as an employer being responsible for my employees, and what it does to that relationship. And it's really similar to the tortious liability point we stepped in. Is there a point where, there's a point in law where I'm no longer responsible for my employees' behavior, when they're when they're acting completely off the scale, when there's stuff they're acting and behaving in a way that I can't be expected reasonably to control? The question starts to become whether that vicarious liability for being responsible for them, that halts at some point. And the question just starting to be asked is there a nature of a point of the behavior of the technology different to just as the currently technologies and software systems in place across the enterprise at the moment? Is there a point where this should fall over? And actually, one of the more interesting pieces, and again, this is a current consultation open at the moment, is around bias. And of course, bias in particular, people are looking at bias and use of AI within the workplace, and whether there is intrinsic bias from the data it's picking up to then analyze, to then come back and feedback results. And also just in things like credit and mortgage card applications, et cetera, where if we've already done some things for 40 years in a certain way and it picks up from the data we've always done that, then hang on a sec, if repeating that behavior, because it's learnt the pattern that we've done, if repeating that behavior happens to show that the fact that we've been biased in what we've done because we don't like certain types of society, we don't want to offer loans to people from this area, et cetera, should that happen? So this algorithmic transparency is an important point, which is just being seized upon by politicians at the moment. There's a consultation up at the moment. At the moment, so there's a consultation with the House of Commons. But at the moment, the law is really clear in actually saying there isn't too much law around this point. You have general obligations in relation to how you behave your employees and your customers and against non-discrimination and the Discrimination Acts to not show those kind of biases and discriminations. And that's what the obligation is. And if you get challenged in relation to that, you have to be able to work back and show the methodology of the decision that you've made. And that's the challenge. That's the challenge that was faced by the new technologies as well as any older technologies. So that's a bit of a canter through the law, because actually in the conclusion really is there's lots of interesting bits of areas for challenge. There's lots of bits currently being thought about, and it's so good that we're 2 years further on where now people are properly talking about them, but the answers really haven't changed. So what do I think about the projects implementing artificial intelligence and some of the risks and issues? And I'm thinking risks and issues from the lawyer's perspective rather than more generally as projects. Well, how do I think those implementation projects are different or more challenging as against someone who's just doing a general software implementation project, system integration project, some kind of just generic outsourcing, someone's using a cloud service and they're implementing that for the first time. Why are these projects a little bit different? Well, I suppose the first thing is that actually there's a human appetite for risk. So there's an appetite for risk which is based around humans doing services or
more better, more widely understood systems and softwares and technologies doing services. People are comfortable and they say, actually, I'm going to get him to come in and do something, and I know he won't be perfect, but I can deal with that. Or actually, I'm going to come in and use a Salesforce CRM, and I know there's problems because Bob down the road uses one of those, but I'm okay with an area problem. That trust level at the moment in relation to use of artificial intelligence systems, because everyone reads the same papers, we've all watched the same documentaries, we've all seen the same movies, and we all think it might be Terminator that's coming along. That trust level isn't there, actually, and that's difficult. Because actually, what we inherently do then, as a buyer or a user of those sort of services, become a little bit more conservative, and we accept more exacting standards. And what that means is people like me coming along in a contract saying you must guarantee and promise that da-da-da-da-da-da-da. Now, tech doesn't work like that. No technology is infallible, and there's all problems. But actually, our lack of trust just at the moment means it's very hard for people to want to use these things, but also then become more conservative in how they're contracting for them. The implementation risk isn't as easily transferred. And this came home to me, I suppose, a little bit when we started to use some very basic machine learning tools in relation to contract review tasks back in my office. Can I teach it to have a look at certain clauses? Actually, it was on data breach. How liable are you for data breach under 400 contracts that you've got? Can I have a quick look? What was obvious and what wasn't quite sold, but what became really obvious is that actually the machine learning, it needs to be taught. It's not in a traditional sense when I procure a service from an IT supplier. I'm quite often just saying, right, your responsibility, your problem, please go and implement and I'll come back and expect it to happen. But of course, that's not the case. It can't work without it being taught properly. So I had an involvement in my usage beyond just signing a contract and saying, can't wait for it to go live. And I think a vast majority of the projects, certainly that I've seen being talked about, retain that customer involvement phase. And that's a bit different. And I know agile development technologies also require that, and that's also hard for buyers of technologies not used to that. There's a reliance on garbage in, garbage out. If I give something crap data, then my expectation level shouldn't be that it's completely fixed and absolutely bulletproof by the time that data comes back out to me or is being used to base something on. Now, of course, the worst people in relation, we'll come on to why it's a problem in a minute, but actually people don't really yet still properly understand the data sets that they hold. Of course, we store more and more data all the time. What does good look like? I suppose a little bit related to that appetite for risk. If we start thinking about how we contract for applying human measures to AI performance, and what I mean by that is we get very comfortable with things like service levels for certain tasks, especially the sort of tasks that people are talking about this type of technology replacing. If I'm just talking about availability, that's easy, right? I can start talking about uptimes and do measures and things like stopwatches. If I'm starting to replace a task that one of my junior lawyers is doing, that's a human-based task. So how am I starting to think about the accuracy of what he was doing previously? How many mistakes is he making? How many typos was he making? Am I happy to apply that same measure that I know Tom, my paralegal, makes 10 spelling mistakes per 100 pages? Am I happy to apply that same measure to my artificial intelligence? Well, no. I'm not. Just generally, I'm a buyer. I think it should be faultless. And it will be a lot better, but should it be faultless? Should it have no errors at all? And I think public expectation, buyers' expectation, and perhaps have been oversold slightly, is that there should be an expectation that everything will be perfect because of the use of that. Just at the moment, we're at that phase, all technologies go through that phase, where the sales and the contractual cycle don't beat. And of course, then there's the issue of kind of identifying and dealing with errors post-live. And I suppose what I mean by that is simply that how errors arise and when errors are spotted, I think are a little bit different once the technology is in place than it would be under a normal IT system or a different type of maybe just backbone IT system. And actually, a governance committee or some kind of service level reporting might not be the thing that's spotting that there's a problem in this way, shape, or form. But of course, you're being presented with a contract which is just a cut and paste from something's used previously. So what about getting ourselves ready for IT? For AI AI contracting process? Well, I won't go too much into this because this is a bit lawyer heavy, I suppose, or just a bit more interesting to lawyers than others. It's kind of about the kind of contract that we start working from. There is nothing new under the sun. So what do? Do we start writing it all from scratch? No. So we're borrowing from a previous contract we might have used elsewhere. And the types of contracts typically being driven at the moment that I'm seeing as well as kind of a deployment model, a software as a service sort of a thing. an outcome really outsourced kind of a contracting relation, or something based around it's sort of the value that something's going to deliver. And really, it's all taking the forms of three types of contract, really, at the moment. One's a real software license of a way, shape, or form, or an outsourcing agreement, or a cloud contract. So some of the problems with those are that the key features of software license can be quite helpful, actually, just at the moment. Actually, in particular, if it's a deployment model, and people are worried about data privacy, because, of course, it was being deployed on your mistake, the data isn't going anywhere, et cetera, then that means some of your DP concerns might be minimized because you're not worried about data going anywhere and being interacted by everyone. What else can it do? Well, actually, if it's warranted to software specifications, that's great, but there's probably no warranties in relation to, I'm sorry, I should have said warranties are really important because they're a strong contractual promise. And if someone breaches a warranty, it means you can sue them for damages. Okay, so that's why lawyers love a warranty. Just a normal shall isn't good enough. That's why we want things to be warranted. So in relation to a software kind of a license approach, where you're saying the AI will comply with this manual, that's kind of a description of its spec, not the outcome. And of course, there's a miss because people are wanting to buy the outcome, the thing it's going to try and do, not really care too much about the thing and how it's set up. And again, there's some other things that the main supplier obligation is typically around the support and the maintenance, especially whilst the thing's gone live. So one of the options, software license kind of a based model. You'll see this, I think, in particular, I think Watson, the last time I saw Watson was really pushed out in relation to that way. So it's got some positives in relation to it, but from a buyer's perspective, I'm not quite sure it's doing what you think you're buying. Cloud contracts are pretty popular, and that's very natural in terms of a base for an AI-based product, and that's quite sensible, isn't it? Because actually a lot of the tools are actually not being deployed, they're being used by a cloud-based service, and the data and the analytics is being done in the cloud as well. They're typically pretty poor terms, again, from a lawyer's perspective, especially for the low value or pilot and the trial phase. And of course, for a lot of bigger businesses, I think are still in pilot and trial mode. In typically those areas that lawyers love to worry about, which laws apply, where's the data going to be located, what's warranties in relation to it, and of course, limits of liability. If you've ever had to spend time with us in a room with contracts, that's the sort of stuff we love. Well, those are the sort of things that from a buyer's perspective are usually pretty poor terms, typically, especially on lower value cloud contracting terms. And actually, even as the contract gets slightly bigger, if it's higher value, and there's probably more of an ability to discuss and negotiate, even in cloud, there are some areas you can have further and greater discussions around exit and portability and data security and data privacy. You can obviously have all of these areas of discussion. And in cloud, that's starting to become a mature conversation, but I don't really think we're seeing those conversations just in AI and machine learning tools just yet. And outsourcing, I suppose, is an interesting model, but in a way it's slightly similar to business process outsourcing, I suppose, outsourcing contractual arrangements in relation to artificial intelligence. And the interesting piece around this, one of the key differences around this is we're getting more used in outsourcing. We've become used to discussions and commitments around the outcome. So not just about what you're going to do, but about what it's going to deliver. Because in some ways, people are less and less bothered, I think, in certain parts of their lives around how it's done. They're just interested in the outcome in relation to it, and outsourcing has moved into that space a little bit, especially what they call business process, where someone's outsourced maybe your HR function. So that model, that contractual model, gives a little bit more certainty in relation to the outcomes being promised. Not just that it'll be read and it'll do this, it'll be read and it'll run on this PC, but also that it'll start doing this thing. So what are the key areas contractually? I'll whiz through this because this is a bit more legally relevant, other than to say, well, the responsibility for the actions of the artificial intelligence, this is not an uncommon clause, especially with some of the more major products, AI products, which are out there sort of being pushed. Those kind of clauses would say we're not responsible for how it works. We're not responsible for the decisions it makes. Yep. You use it, we promise it will work like this, but what it gives you, the data it gives you, the analysis, the results, that's your responsibility. Sometimes it's pretty justified because it depends really on what the tool is and what you're paying for it and how it's being sold. But sometimes this is where the sales, and this is where the reality of what the contractual documents take don't quite meet. Because quite often people are sold a solution which we guarantee to do this, but actually language says we're not responsible in any way, shape, or form for what it does. Now this is the biggest problem out there at the moment and this is in particular problematic in what they call RPA, robotic process automation, actually, not necessarily just in artificial intelligence. And there's even a bit of a case law as well, and lawyers love a case law coming up. But actually, quite often this software needs to interact and use other things. And that might be other bits of software, it could be other bits of data. And actually, AR software is using those bits. And of course, going back to intellectual property, if you're using somebody else's intellectual property, be that software, be that data, then you need their permission to do so. Or you're going to have to rely on some really obscure bits of law, which are not a good place to be. The responsibility for checking this is going to be the customers. If I'm buying in a tool to do something and I need it to look at all my finance and figures, if I need it to look at everything else, if I need it to look at all my data, if I need to look at all my software, all the data provided to all my customers, I've got to be responsible for checking the right permissions are in place to do that. It's important because quite often some of the tools, and I can't remember this is one of the big ERP provider, finance platform providers, they say you can't use any data mining robots or similar data gathering tools to use this. So actually their license says you can't use the sort of tools that people want to bring in to start doing the analytics that you're thinking to do. And customers are signing up to these great new AI machine learning contracts and then realizing that they haven't got the permissions to allow it to crawl all over their business or their data that they wanted. And it's starting to, and we've seen, so this is a real live problem just going on at the moment. It's a customer responsibility in buying in, and we have got a bit of case law, because of course what quite often happens is, very sadly, people sign contracts and lawyers never get involved again, because they go, crikey, they've really hindered the process, can we just get on and run it? So SAP launched an SAP system 2005 with Diageo. Agreement goes on and on and on. They bought a certain type of product. 15 years later or 10 years later, the product's completely different. They go back and look at the license, which was previously on a user basis, means an individual's allowed to use. And now, it's obviously being used by bots. It's being used by a whole host of automated tools. The contract's not kept up, of course, and suddenly Diageo find themselves in a lot of trouble, and the court's saying, well, you've got the wrong license, not in place, and that's quite a lot of money that you owe SAP. So the licensing issue is real and live and out there just at the moment. But really, one of the most important things in terms of getting ready is in relation to, it's all about the data. It really is all about the data in terms of the hindrance of the projects, or what will most hinder projects going on. And real live examples are, DeepMind getting involved with Google, DeepMind getting involved with the NHS, doing some great, lovely work they're trying to do in relation to analytics, in relation to healthcare data, et cetera, but they haven't got the understanding of the data. Between the NHS and Google, they haven't got the understanding of the data and the permissions that they needed to have to be able to do the project. You have to know where the data is coming from, and you have to know what you're going to do with it before you can hope to do so with the appropriate legal permissions to allow AI to do it. Let me skip that. I can talk about that a bit more legal interesting. So sorry, that was a bit of a canter through. I think we've got a little bit of time for questions as well. Has anyone got any questions? Oh, thanks.